Hi, and welcome to today's EB-5 interview. I'm Trevor O'Neill with LA Life Regional Center. We're here to discuss the concept of concurrent filing within the context of EB-5 investment immigration program and its comparison with the process in China. Today, our guest speaker is immigration attorney David Van Voren with David Herson and Partners, and he has extensive knowledge and experience in this area. David, thank you for joining us. How does concurrent filing benefit applicants who are already here in the United States?
So concurrent filing is eligible or available to applicants already within the U.S., provided they have entered legally and stayed in the U.S. usually for an amount of time over 90 days. If they meet those eligibility requirements, they can do a concurrent filing of the I-526 petition, the EB-5 petition, together with the I-45 adjustment of status application. While they apply for the I-45, they also apply for what's called the I-765 work authorization document, as well as the I-131 advanced parole travel document. So essentially the I-765, I-131 should be approved while they're waiting for their green card. But if it's approved, normally they get approved in what we call a combo card. So you'll have a single card, gives you work authorization, travel authorization, and basically very little limitations on what you can do while you're waiting for the green card.
So you mentioned a 90-day waiting period from the point that an immigrant arrives in the United States to the point that they do the concurrent filing. Tell us, why is that? There are different ways people can come here under different types of visas, whether it's an immigrant visa or a non-immigrant visa. So I imagine that might have something to do with it?
Yeah, this is very important. So basically, USCIS, or Immigration Department, they do not want any foreign nationals coming in under one visa with the purpose of actually doing something else. So that would include potentially filing an adjustment of status, that I-45. So kind of how they determine if they think a specific applicant had that intent is whether they filed their I-45 before 90 days or after 90 days. If they've been in the US after 90 days, they should be okay. But if it's before 90 days, potentially we'll have some issues because they could claim that you entered the US and that was your plan all along. And also just want to add that you should never enter the US with the intent to file that adjustment of status. But if you enter the US and plans change, then that's totally fine, and plans do frequently change. So if you enter the US, you should not have that intent to apply the adjustment of status. But once you enter, 90 days have passed, the situation has changed, then you are eligible to file that adjustment of status.
Okay. So hypothetically, someone who came to the United States on a B visa, let's say, that's good for a 6-month period, they didn't originally intend to transition to an EB-5 investor, but they are here, and after 90 days has passed, technically they could.
That's correct.
Okay. Would the same stand for someone who's here on a student visa?
Yeah, that pretty much applies to any non-immigrant visa. So F1 student visas, B visas, visitor visas, and don't want to get too complicated, but potentially if they have a H-1B or L-1 work visa, then they don't have to worry about this 90-day requirement. So because those are special visa types that allow that holder to have immigrant intent. So if you have H-1B or L-1, huge benefit, don't even have to worry about that 90-day wait, but other non-immigrant visa types, they will look at that.
Yeah, so it's really a difference of if you're here on an immigrant visa or a non-immigrant visa type.
Correct.
Yeah. So we're talking about people who are already here in the United States on one of these visas, whether it be immigrant visa or non-immigrant visa. So let's talk about somebody who may be in China and wants to undertake this process of an EB-5 investment and come to the United States as soon as they can. What would the process be for them?
Honestly speaking, I would have to advise that client that they cannot enter the US with that intent to do the concurrent filing. Now, as I just said, if they enter the US and plans change, then that may become an option. But to be careful, and you do want to be careful because we do see a lot of applicants, doing this now, and you never know how USCIS, how strictly they may be monitoring this kind of whole concurrent filings and when exactly cases are filed. But if someone is outside China with the intent to do a concurrent filing, I would have to advise them not to do that. Obviously, all of the other different scenarios I talked about and how plans can change, that still applies.
So absent the concurrent filing, if you have an investor who is in China and then becomes an EB-5 investor, at what point in time would they be allowed to enter the United States?
So if they have a valid visa, they're always able to enter, but it just becomes a question of the planning and kind of what their intent is when they enter.
And then those who are already here in the United States, when it comes time for their adjustment of status, it differs from somebody who is not in the United States, correct?
Yeah, so, a simple case, potentially a student who's been on here for F1 for a couple of years and hasn't left the US. That's obviously very standard, kind of situation where there would be no issues to file an adjustment of status. They've already been in the country for a couple of years. Obviously, just based on that, they maybe didn't even have an EB-5 case when they entered the US. So, there's no pre-planned intent to file that adjustment of status there.
And so the investor, the EB-5 investor who is in China and it comes time for their adjustment of status, their process is going to be different in their home country, correct?
That's correct. And in that respect, so we wouldn't even use that adjustment of status language. So in their process, EB-5 petition, the I-526 gets approved, it gets sent to the consulate if they're in China. That consulate will be the Guangzhou consulate, and they wait for their interview essentially to be called.
Which is the way it had always traditionally been done prior to the Reform and Integrity Act.
That's correct. So concurrent filing has been around for a long time, but never for the EB-5 category. It's only the 2022 law that made concurrent filing an option for EB-5 investors. So before 2022, there would have been no EB-5 investors with concurrent filing.
Yep, but it's a great option now for those who are looking to make their investment in the United States and their pathway to a green card. Well, David, thank you so much for joining us and answering our questions today. If you're ready to start your EB-5 journey, contact us at LA Life Regional Center.